And your job is to make sure you don't ever look the other way. Look the other way.
4 words that sum up their entire case. 4 words that sum up the hopes of those who tried to deceive you. And conflicts of interest doesn't matter. Look the other way. Magic hairs, magic glass. Look the other way. Late night calls and Google searches. Falsified affidavits, inverted videos, and butt dials galore. Just look the other way. That's what they want. That's what they're counting on. But the incontrovertible fact is you have been lied to. And your job is to make sure you don't ever look the other way. 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 4 words that sum up their entire case. 4 words that sum up the hopes of those who tried to deceive you. Conflicts of interest doesn't matter. Look the other way. Magic hairs, magic glass. Look the other way. Late night calls and Google searches. Falsified affidavits, inverted videos, and butt dials galore. Just look the other way. That's what they want. That's what they're counting on. But the incontrovertible fact is you have been lied to. And your job is to make sure you don't ever look the other way. Look the other way. Look the other way. Look the other way.
Look the other way. 4 words that sum up the Commonwealth's entire case. 4 words that sum up the hopes of those who have tried to deceive you. Conflicts of interest? Doesn't matter. Just look the other way. Magic hairs, magic glass. Look the other way. Late night calls and Google searches, falsified affidavits, inverted videos, and butt dials galore. Just look the other way. That's what they want. That's what they're counting on, but the uncontrovertible fact is you have been lied to in this courtroom. And your job is to make sure you don't ever look the other way.
Hello everyone. How are we all? Hope we're all good. We're testing out audio again today. I don't know how we're going to go, but we do have Jason, aka Not Hailey, coming up to give us some insights as to what's happening, boots on the ground today. We might have a little, we might have a few hiccups with audio. We'll see how we go. I think I have it set up correctly. It's a real pain with raw audio. So, oh my God, Quizzy, I am so anxious too. Like, I don't know about, I don't know. I'm just not a good waiter. Audio sounds great. Thank you. I'm not a good waiter, and so waiting for the verdict is killing me. So I'm right there with you with the anxiousness. Also just having, a bit of downtime when my computer broke. That was actually really good, that bit of downtime, because I was getting anxious. Every time Brenna opens his mouth, he gives me a freaking new wave of anxiousness. So I needed to have like that bit of downtime. So yeah. So how is everyone? How are we all? Thank you for the sound check. Kerry, much appreciated. Let's do a little check for you. How about you? Oh, you know what I did? Oh, freaking forgot to press the low latency. So you guys, God damn it, I'm useless. You guys are not going to hear me as in as real time today as you normally would, like as you did yesterday. You're going to be a little bit behind, so don't. And we do usually. I didn't do the. Anyway, Kerry, test highlighting the chat. I forgot to set the stream to low latency. Something I'm going to probably forget to do over and over again, but oh well, we'll get there. But anyway, have a go at highlighting a comment in chat. Kevy should be able to send it through. Yes, there you go. Nice one. Good stuff. And then click it again to unhighlight it. Alright, so now the prosecution is using the sentence. Look the other way. Yes, Elena. Hello, Carol M. Quizzical. Your voice is soothing after a stressful day watching the spinning fan, the only fan. Oh, good gracious. Alright, Kevy, you are in the driver's seat once Jason comes up for the chat comments. And try to keep it on topic so we're not like all over the shop. But he's got a bit of news to tell us this morning, so that would be awesome. And I think he might have a video. I'm not sure what he's got. I just jumped on it at the last second and not sure. But if we're lucky, he'll have some news and maybe even a little bit of video. But anyway, all right, let's have a look. What do we got going on? All right, so those who don't know, we've got a new bot. The bot's got a number of settings that we can screw around with. And so when you see people typing in the chat with an exclamation mark and then a bot command, I'll give you all some more bonus points to play with the bot. They're just the longer you chat, or the more often that you chat, the more points that you get. But I am handing them out for free as well. They're just like interaction points, we'll call them. But I am handing them out for free, so we'll do a little round of that when we're finished mucking around today. There you go. So Carol M typed in how many points has she got using the exclamation mark to tell the bot she's speaking to it, and the bot replied, "You have 26 points." So that's one of the things that you can do. So where did who go? Thank you, Gracie. Where did who go? Flamingo? Flamingo? I don't know why my brain's reading shit wrong today. I guess it does it every day, but there's always someone's name I get hooked on incorrectly, so it's your turn today, Flamingo Chicky. What do you think the verdict will be? I have no idea, Elena. Like, honestly, it's a different question to what I want the verdict to be versus what is the makeup of the jury and what are they going to decide? Oh yeah, that's what we can yak about while we're waiting for Jason. I guess I better unmute over there so I can hear Jason actually turn up. Give me 1 second. Let me unmute that tab so I can hear when Jason turns up. And I'm buffering. Am I? I know. Why am I buffering? Okay. Let me have a look. Why am I buffering? Let me stop the virtual camera. Maybe that might be it. That might be causing some issues. How's that? We'll leave the virtual camera off for a bit. And still choppy. No buffer for Edie. No buffer for styling. We ain't got no quit. I got thrown out, but I'm back. Nope, no buffering. Alright. 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 Thank you, chat. It's stopped now? All right, so I think it might have been because I had the virtual camera switched on, which is one of my little experiments to send a guest the feed while we're, like the feed that you guys are watching, so they don't have to open YouTube and create, you know, that whole feedback echo that happens. But we'll see. Goldfish is good. All right, coolies, we're all good. Back to good. Let's go, let's go talk about this topic. Jury issues for 2.0. Right. Let's do this. And this. And share it with you guys. There we go. God, I love it when shit works. We'll see how long it works for. I broke the chat last time. I don't know how I broke the chat. Somehow I broke the chat last time. So fingers crossed I don't break it again today. Alright. What we don't have on here is chat. Give me one sec. Let me... Chat highlights. I don't have this on the screen here, so... Radio. And then... I forget what button it is. This one. Right. Hopefully they are on the screen in a good place soon. Alright. Lock that down so I don't have to freaking accidentally click on it. Oh, I cut too much off. Wait a second. Hey, the fun. There we go. Alright, so we might move that down just a little bit so it's not in front of everything. If it's more than 2 lines, if it's a big comment, then we're only going to see 1 line of it, but I don't want it to be too much in the way of what I'm reading to you, so. Alright. So, I'm doing a bit of research with the Chat GPT and looking up the laws and shit, so this is, hang on, let me scroll back past all of this. Right. So, Judge Canoni said that the lesser included charge of OUI, she was adding that sua sponte because she said so under her own authority, which is, she does have, under Massachusetts law, she does actually have the authority to do that, even though both parties did not necessarily want it. So, like, I think last stream, if you were tuned in last stream, I wasn't sure, so I decided to do some research on it so I can be sure and answer your questions properly. But you have to remember to take the chat links off again when we're reading a screen, Kevy. But anyway, yeah, so I did look it up so that, you know, I could be a little bit more precise in my answer about that. So I think I might just hide them myself for this screen, just for the time being. We'll come back to your comments in a minute. Yeah, so under Massachusetts law, she does actually have the discretion to include lessers if she wants to. But there are times when it's improper for her to do that. So that was what I was looking at as to how proper it is, basically. So from Commonwealth versus Santo and Commonwealth versus Woodward. I looked them both up and checked. They actually do exist. They are actual legal proceedings. They do read the way that chat's telling me. If there is any view of the evidence that would support conviction on the lesser instead of the greater, the judge may include it. In other words, even if the state says we only, even if the state and the defense say we want murder or bust, the judge can say, well, tough, the jury gets it anyway. But there is a problem with it, because Judge Cannoni has a documented pattern of favouring the Commonwealth and interfering with the defence strategy and curtailing the defence's ability to put on a defence. So it's not as straightforward as she's making out it is, but there is a problem with it, because I have been logging all of Judge Bevy's issues, reversible rulings, possibly, potential, we'll call them potential reversible rulings, so that at the end of the trial we could organise them into some sort of like a semblance of how you would go about appealing certain things, because you can't just, I'm up to number 60 something right now. You can't do that to the, yay. Did I have alerts in here? Oh no, I didn't have the alerts in here. Thank you for the, hang on, let me, turn that back on. Let me highlight that. Thank you for the $5. Gracie Grace. Fish and shops for me. I'll take the coffee, thanks. But yeah, there is an issue with this, because it fucks up what she's kind of railroading the defense into not being able to appeal a great number of these challenges. So from 1 to 60, I was trying to organize, like, I was noting, like, I was documenting fucking everything from trial 1.0 through to trial 2.0. And I forgot what number we're up to, but I know it's over 60 now. But you can only do, if you do that, if you try to appeal 60 issues through the appeals court, that's just overwhelming them, and they're just going to boot it back out. So you need to pick your 3 best and play on those 3 bests. And then you add the extras. For example, all of your judge bias and all that sort of stuff. You add it as cumulative error. So it's not that it's useless. It's just that you'd pick your 3 best and then you'd use the rest of them as, cumulative bias or cumulative misconduct, or however you want to go about it. So that's basically, that's how that would work. But what Judge Bev has done here by including this OUI lesser, I wasn't sure yesterday whether the defense had asked for it, but I had to listen back over the conference to get a better grip on what was actually said. And it was, the Commonwealth didn't necessarily want the lesser included. They were all or bust. And then the defense agreed. And when the judge said, I'm doing it anyway, the defense also put it on the record that they objected. But what this does, by her doing this, is it kind of narrows down, what they can appeal if she only gets convicted on the OUI. I'm not sure that she would appeal much if she gets convicted on the OUI. I guess it depends on sentencing. If the judge decides to go out of her way to put her in jail. So I also looked up sentencing for this as well, just so that you get an idea of how that might go. But I just wanted to point out that there's an issue. And the issue is that this is kind of thwarting all of the best appeals that the defense had. So this is actually a strategy on the judge's part. So I asked the chat, how does the 60 plus reversible errors that we've been tracking over trials 1 and 2, how is that impacted, and is Canoni subverting all the possible paths to appeal with this move? And it said pretty much yes, that's what we're looking at. Because the reversible errors only matter if there's a conviction on a tainted charge. So before she put that in, we had, 3 tainted charges, and we had a lot of evidence to say that these were tainted. Now that she's added that in, it's not necessarily a tainted charge anymore, because Karen's actually admitted that she was drink driving. So it's no longer a tainted charge, and that kind of cancels out all of the errors, which included, the forensic suppression, the witness coaching, the digital evidence tampering, the jury tampering, the voir dire manipulations, the jury instructions misrepresenting reasonable doubt, the third-party culprit denial. All of that stuff kind of gets cancelled out because she was drink driving. She admits she was drink driving. It's no longer tainted charges. So what this move means, on top of the fact that Bev's being strategic here, is that she actually acknowledges, this move acknowledges, is her acknowledgement rather, that the charges 1, 2, and 3 as they stood were tainted. She already acknowledges it. That's why she added the OUI, despite the defense and prosecution not necessarily wanting those. So she's given a soft landing for the jury. So she's kind of directing their verdict by doing this, essentially. But it is a soft landing. That's the way the appeals will look at it, which is much harder hill to die on at appellate level. So, but it undermines the entire all or nothing strategy. So when the judge does something like this that undermines the defence's strategy, then there is a path to appeal, but it's just not as strong as it was with the 3 tainted charges as they stood. So nonetheless, the jury only sees 7 paths to guilt. Okay, the way the jury form is laid out, there's 7 paths to guilt and only 3 paths to acquittal. Well, 7 paths to guilt on charge 2 and only 1 path to acquittal on charge 2. So, and then you've got charge 1 and 3 either side of that, which have 1 path. So 7, 8, 9. So you got 9 paths to guilt and only 3 paths to acquittal. So that's a bit of an issue. So that's why the defense has lodged some changes to the jury forms, a motion for the change to the jury forms, which Judge Bev promptly denied. But that's what they were looking at, the 7 paths to guilt just for that second charge and lessers. So the logic becomes, well, we do think she was drinking. Well, let's just check that box. Even though the collision is what ties her to the death, which AJ rightly pointed out to the jury, and the defense strategy required the jury to treat this as a singular event, like the fact that the collision happened. So Coney has made sure that, even if they believe she didn't kill John, there's still going to be a conviction. And so that's why she added it, but she's also acknowledging by doing that charges 1, 2, and 3 as they stood were tainted. So, is this subverting the appeals process? Abso-freaking-lutely. So, but it is legally allowed. So, so that's a bit of a problem. But that gives you a better idea why Judge Bev is doing it. And it wasn't Karen that asked for it. And what it does is it makes the biggest systemic failures that we were listing, 60 odd plus of them, the cover up, the evidence tampering, the witness coaching, it's probably functionally irrelevant if the jury comes back with just the OUI. So from that point, paths to, hang on, I've got to go back a little bit further. That was all my notes there. Lesser included. About the jail sentence, radio. So what does an OUI actually mean? A lot of people are saying, well, she could throw her in jail for 2 years, up to 2.5 years. And she possibly could, but in Massachusetts, time served refers to time actually spent in jail, not on bond. I was wrong about that. I apologise. Where my brain was actually, I'll come back to that, where my brain was when I was thinking through that. It wasn't actually about the bond. It was about her licence suspension. So I'll come back to that in a second. But so yeah, time spent in jail is time served, or time spent in pre-trial detention is also time served. And in some cases, house arrest with GPS if the terms are restrictive enough. But Karen was out on bond. She wasn't confined and she wasn't under, house arrest or anything like that. So, so in the worst case scenario, if she is found guilty of OUI, she's looking at, under Massachusetts law, 90 section 24 1A.1, first offence OUI penalty. So first offence is 2.5 years in House of Corrections. Most first offenders don't get jail time. They get probation, driver's education, fines, and licence suspension. But a judge can impose jail if they're being punitive. The conditions that they might impose jail under, if someone was injured. This is just for a first offence. If you're a repeat offender, then obviously you're asking for it. But I'm just talking about first offences here, how it normally goes. So imagine Coney feels salty as usual, and hands down 90 days or 6 months or even the maximum just to be vindictive, then Karen would have to serve that. No credit for the last 3 years of hell she's endured unless the court imposed detention that would have counted, and they didn't. So she didn't have any time under GPS monitoring. So even if they do throw her a bone and go, well, even if it's just a misdemeanor, she's already lost 3 years of her life. She potentially still could end up in jail. Her relationship is gone. All her relationships are spent. Her reputation is gone, and, her peace of mind is also gone. So there's all of that. Just checking for Jason. He's still busy. Okay, I think. Right, so this is where I was talking about the licence suspension. So if the judge was going to impose a licence a suspension, I was thinking that the time she's already been suspended for. So if the judge said, I'm going to suspend your licence for 3 years rather than go to jail because she's a first offender, and she's just spent 3 years suspended, where my brain was going was that might be counted as, already served. That suspension has already been served, but it's not actually counted. So the RMV suspension doesn't count towards any license and suspension that comes from after a conviction. So it's 2 bites of the apple, essentially. if the jury convicts her, OUI first offence, the court can still impose a new suspension, mandatory alcohol education program, or fines, probation, and possibly jail, although jail is unlikely for first offenders. And that's on top of the suspensions that she's already endured. So it's completely separate. So I was wrong about that too. So it's always good to check before you put your money where your mouth is, which is what I was saying the other day. Like, I'm not sure how this all works. Let me research it. So this is how it seems to be looking. So yeah, the judge can impose jail on a first offence if someone was injured. So that might happen because she can, even though the jury's going to say, well, we don't believe she injured John, the judge turns around and says, well, I believe you did, so I'm going to impose jail anyway. Then the O'Keefes get, you know, their bite of the apple. The Commonwealth kind of gets their win, basically. When wouldn't it be overturned on appeal? Well, the circumstances under which Canoni could legally impose jail and appellate courts will likely let it stand would be when it's within the statutory limit. So anything between 1 day and 2.5 years, the appellate courts won't blink. Even if she abused discretion or relied on improper evidence or violated constitutional rights. So, sorry, unless she abused discretion. Sorry. So if she, so some of those, you know, 60 things that we've been listing over the past 2 trials could come into account if she over imposes punishment for the DUI. Sorry, OUI, you guys call it. In Australia, we call it driving under the influence. I think you guys call it operating under the influence, but it's the same thing. If she ties it to conduct in the record, like if she says, well, the jury found you guilty and I'm basing this sentence on your reckless disregard for safety, even though it's total bullshit, well, it does give a cover, and the appellate court's probably going to go, yeah, that's all right. You can have that one as well. But if she makes it seem procedural, so she couches it as this is the standard sentencing range under Massachusetts guidelines for this offence, which is what she's probably likely to do, the appellate courts are rarely going to overturn it just because it's harsh. So when would it be appealable? If she mentions her dislike for the defendant, or she says anything like, if she throws the book at Karen without citing aggravating factors, you know, that would be appealable. And also, like, if she cites charges she was acquitted of, if she's like, the jury didn't convict you of manslaughter, but I believe you did it, and so I'm going to give you a jail sentence. If she does something like that, well, that would be appealable. But, so yeah, essentially, it does look like Canoni's kind of limiting what the defense is able to do in appeals now. So that's the bottom line, which is dastardly of her, right? It depends on the state and what they call it. I've heard OUI, DUI, and DWI, right? Same. I missed some of the comments because I was on the other screen reading, so, but yeah, interesting, right? Okay, get a grip now, Kevy. I know it's hard to actually work out how to unhighlight because it's a little bit slow in responding, isn't it? All right. So yeah, essentially, this is the judge doing Karen dirty. Essentially, that's where I landed. But I'm sure Jason's got some feedback about that as well. Like, you know, this is just me looking at doing research and not really knowing much about it, getting ChatGPT to tell me like the outlines and then going and researching whether or not that shit's true, which it seems like it is. So we'll get some feedback from Jason on that because he knows how it works locally like better than I do. Seems pretty up to date on Massachusetts stuff. I'm still trying to get us a lawyer to come and chat with us. Obviously, Aussie Overlord will come and chat anytime that I want him to. But he's not a Massachusetts lawyer, so trying my best to get someone to come up and talk with us. But, you know, we're not a very big channel, so we're not exactly, you know, in the popularity scale yet, but we're getting there. All right, so Compote says, when I saw the OUI charge, I was infuriated. Me too. Me too. Especially, like, going back now, Corny, and, like, listening to the conference again a second time just to hear how that went down. Like, the first time it kind of went over my head what they were saying. So it wasn't until I was looking into it like this closely where I was like, yeah, interesting. Because neither the prosecution nor the defense wanted it. So, mass lawyer on Melanie Little's show says more than likely 2-year sentence. Custodial, yeah. But Edie, that's because but what she's got to do though is say, yeah, but someone was injured. So she's got to actually override the jury's decision that nobody was injured due to her driving. She's got to be really careful about how she says it. If she just says, oh, you're putting the public in danger, so I'm going to give you a two-year sentence because the level was egregious, the level of your drinking was egregious. If she does that, then it's fine, then he's right. Which he's probably expecting that she will do because that's what most judges would do. I don't think he would be prepared to say, yeah, but this judge is totally freaking corrupt. But we're allowed to say it because we don't have to work in Massachusetts under that judge at any time or other judges that might be connected to her. So, yeah, I thought it was Karen who decided it too. So I think I was watching, I forget whose stream I was watching. I think I was watching Andrea's stream and she suggested that the defense wanted it. Then I was watching Melanie's stream and she was like, no, the defense didn't want it. So I had to go back and watch it all over again to work out who wanted it and who didn't. And then I caught the judge saying, well, I can do whatever the fuck I like because I'm Judge Beverly, do whatever the fuck I like, Canoni. So anyway, it's going to be the harshest possible, exactly, Amber E. Exactly. You know, and I just don't expect any local lawyer who's actually practicing right now to come out and say that. I actually do expect any lawyer who's practicing right now to come out and say, yeah, you know what, I'm too weak to say that Judge Canoni is a freaking train wreck, basically. Anyway, that just seems to be how it is. And, you know, none of the local lawyers want to say that outright because, you know, they've still got to work in the county, so... Andrew D. Myers is a MA attorney who might go on your show. I'll try it, Kim. I'll try him because he has actually featured in some of my mashups. So I'll give it a bell. I shall give it a bell. I'll tell you who I would like to get on. I'd like to get Nick Ricader on. The Law Pope. And I'll tell you why. First of all, I am not going to judge him for having a past addiction or whatever. I believe he's 60 days sober now. But the main reason is because he started this whole freaking Lawtube thing. I would like to have him on just to, like, I don't think he's much, I don't think he's much into being the person who started the whole Lawtube thing. I think early in the piece he was like, yeah, no, we're not Lawtube, stop saying that. But I think he embraced it a little bit better. But I would just like to have him on because he started it, essentially. Everyone knows he started it. We all attribute it to him, that, you know, everyone appearing on each other's channels during the Johnny Depp trial, that whole lawyer mashups, everything, he started all of that. Well, he wasn't doing the mashups, but it's because he started doing the everyone on each other's live streams, being guests on each other's live streams while commenting on the trial. That whole thing sort of came about because of Nick, and I'd like to pay a tribute to Nick for that. So I'd love it if he would come on. It would be freaking awesome. Because he is the Lawtube Pope. He started it all. So now that he is back on board, he's sober, he's covering the Karen Reid trial, I'd like to throw him in a couple of mashups and then send him an invitation to come and say hi to everybody. Bev's social life just changed. Yeah. That's right, Corn Pope. He wanted no part of it. But you know what? Too bad. I think he embraces it a little bit more now. I'm going to have to be very careful how I word it, because I don't want to upset him by saying, like, you started this shit, man. You're like the king of Lawtube. I don't want to put him offside because I know he's a little bit antsy about that. Like, he didn't want any part of it. So, and I get where he's coming from. If you have a leader, then there's a head to chop off. Do you know what I'm saying? If we're all just doing our own thing, but we all, you know, happen to share an opinion, then you can't chop a head off the snake, you know. But as Turtle Boy is demonstrating here, when there's a head on the snake and they can identify the head of the snake, they can just lop that head off and somehow, you know, shut everyone up. So that's, yes, Corn Pope. That's exactly where your name comes from. We know. That's why she's the Corn Pope. So if you ever watch Nick's stream, you'll get the Corn Pope reference. But anyway, yeah, so that's the point, I think, for Nick was that, you know, if you appoint or anoint someone as the leader, then they become the head of the snake that the government's going to want to chop off when it's not serving its purpose. And that's pretty much how it goes. That's what we're watching with Turtle Boy. Oh, on the Turtle Boy front, for those who aren't on social media and don't know yet, he was so he asked for a bench trial with the Lindsay Gattani harassment stuff. She's trying to get him chucked in jail again for turning up at a hearing. Well, she turned up at a hearing that he was at, and she's trying to get him thrown in jail for that. But anyway, he asked for a bench trial, and the judge just dismissed it all. So he's free of that charge, but he's still got, I think he's got 3 witness intimidation charges dropped now. Yes, fake victim. Thank you, Corny. Fake victim is who we're talking about. I think he's got 3 witness intimidation charges dropped already in the other cases. I think of 18. Could be wrong. I forget the numbers now. I need to have it in front of me to be accurate, but you guys know how it is. He wouldn't mind being associated with it. He just didn't want to be under the rules of an organisation. Right. There was a whole bunch of stuff involved with it, but I got where he was coming from. I did get where he was coming from. Andrew D. Myers is a small new channel. He's an MA attorney. Yes. Thank you, Andrew S. Myers. Are you in a relationship? Hang on. You're saying Andrew D. Myers. Oh, I see what you're doing. We're not getting your name on the screen for some reason. But anyway, yeah, there was stuff that went down with the Lawtube stuff back during the Johnny Depp trial. It was like, you can't go into court and pull faces like that in court, and then the TV cameras catch them, and then it all reflects on all of us. That's one of the rules that he was like, yeah, nah, we don't need those rules. If you want to go to court and pull faces because someone's saying stupid shit in court, you should be allowed to do that because you're independent. So that was kind of where that sort of all came from. But anyway, I'd love to have him on to talk about, you know, the Lawtube as a whole, where that came from, where it started from, and to talk about the Karen Reid trial, because he is so outraged and, you know, suitably outraged like we are. So one of the things I like about Nick's coverage is that he's not an automatic, just because I work in the system, I got to suck up the judge's ass and say nice shit. Or I might have to practice in front of that judge one day, so I can't say anything bad about that court or this process. You know, the line sitters, like Pete and Emily, for example. I mean, I don't hold it against them because they are line sitters. I still like to grab their funny little bits that they talk about or the points that they make in between. It doesn't bother me that they're lines, that they like to sit on the fence. But Nick's not a fence sitter. So, and DUI guy, that's another one. DUI guy. I'm sure if I reached out to DUI guy, he would actually come on the channel. So DUI guy's girlfriend is someone that I communicate with on and off, like about Aidan Carney's stuff. So yeah, I'm pretty sure I can probably get DUI guy on here to have a yak with us as well. But anyway, hello Miss Noma, thanks for joining us. Let me have another check whether Jason's with us yet. Whoops. Oh shit. Oh shit. My meeting timed out. Ah shit. Alright, hang on a second. Let me get back into the meeting and send him another invite. Copy the meeting link. And I'll go tell him that we timed out. Just, oops. Be sure it's different links. Yes, it is. Damn it. Well, there you go. That's the downside of using Brave browser for that. It only sits there for so long. Actually, Kevy, let me send you a link to that in Discord. Send you a link. If you go sit in there and mute your mic, that should keep us open. Pretty sure it's unlimited so long as it's being used. Pretty sure it's unlimited, but it's timing out because no one's in there at the moment. So if I could get you to just follow that link and jump in there, that would be awesome, because that will keep it alive until Jason shows up. So the reason we're waiting on Jason is he was already booked with LTL. So we're just waiting for him to get done there. So Okay, busy morning. Thank you, Gracie. Thank you for the fish and chips. And you have a good morning too. So yeah, Amber, but I don't think Carl will come up now because we all had a bit of a disagreement over shoes, so he might not come up now. A lot of people went over there and harassed him about it, so like oops. That was unplanned. All right. All good. So hopefully Kevin will jump in here and just be a placeholder for me until thank you. Thank you, buddy. Much appreciated. Let me see if this works for you. I don't know. Does that work for you? Or no, you'll probably get it twice if I do that. I'll just turn that off. All right. Now, let me go back. Let me go and test it. Let's go test if this works before Jason gets here. This is not Jason. This is Kevy. So unmute yourself and say something, Kev. Hello. Guest send. You can probably hear it in tandem if you've got both open. You can actually mute the tab so that you're not hearing both. Because I am actually feeding actually I'm only feeding my mic in. I don't know, can you hear me? Yay. Thank you, Miss Noma, for the $1.99 super chat. Glad to have you and Jason both together today. Well, I'll be glad when he gets here, but yes. My system will not handle as I'm still running off a hotspot. Oh, all right. It's okay. You can leave. Whoa. Did you guys hear that? I might have just been through my headphone. All right, fine. You can log out. It's okay. I just got a message. Jason's a few minutes away. It should be right. It should stay alive. I follow JD Allure Explains on YouTube. He's quite knowledgeable at, yeah. Wow. I don't know if you guys can hear that, but I am getting audio from the Brave browser, which is freaking good. All right. Thank you. Thank you. Done. Shouldn't go to sleep. Jason's on his way. He's just sent me a message saying that he's just finishing up a video, which is the video I want to show you. Or I hope he's going to show you. And then he'll jump on. So maybe he's going to keep it open for us. Heavy, if you're getting audio twice, you can mute the tab, just so you know. Right click on the tab and mute it in the Brave Talk chat meeting room. So you're not getting the audio twice. I don't know if you are. I don't even know if you can hear me in there. All right, let's get some other stuff happening here. I do have some more notes about Bev's antics. So I need to go back to the start. Let's go. Let me just work out the current verdict form. So ask ChatGPT, look at the current verdict form. Like, we already know what's wrong with it. It's just something to play with while we're waiting for Jace. Gotta get the right thing on the screen. All right. So I'm not looking at the super chats and highlighted chats. So just so you know, I'm in the other screen because I can read it better there. Bigger writing. But so this is about the verdict forms. I just sent them to ChatGPT and asked for its verdict on how these forms actually look. Oh, half of it's missing, but anyway, that's because I did it yesterday. But anyway, chat says, so the breakdown of the verdict forms. Charge 1, murder in the second degree, only 2 options, not guilty and guilty of offence as charged. No lesser included, no space for unable to reach a verdict or a partial verdict mechanism. So there is a problem with that because the binary framing forces the jury into an all or nothing decision. If they don't believe the second degree murder but think something happened, they're funneled into other charges. So she's using a funneling kind of system, basically. Charge 2, manslaughter OUI. So this is the most outrageous one because this one does the most funneling down to an OUI. Option 1, not guilty of everything, or options 2 to 5, flavors of guilty plus multiple subchecks that could confuse the jury into marking more than one box if not carefully instructed. So the problem is that it's not neutral. It's giving 6 paths to a conviction and only 1 path to an acquittal. And so that's verdict stacking. The structure practically screams, if you think she did anything wrong, here's a smorgasbord of guilt options. So, yeah, so this encourages the jury to compromise their verdicts. Like, here's a compromise, because we can't come to this, let's compromise. So that's likely to happen under, emotion or fatigue, depending on how long they deliberate for. So charge 3, leaving the scene. Again, 2 options, but no way to indicate we agree on this, but are hung on others, which could preserve a partial verdict and avoid a retrial. So this rigid structure again leads into false dichotomies and shuts down nuanced deliberation. But that's the way we do it in Massachusetts, Mr. Jackson. So, yeah, that's what Massachusetts normally does. False dichotomies and nuanced deliberation. Yay, go Massachusetts. Give them a freaking round of applause for destroying justice. The legal strategy. What Jackson should have shoved in her face, which he actually did, was Commonwealth versus Diaz. Verdict slips must reflect clear, unambiguous pathways and not structurally biased towards conviction or dilute the burden of proof. Commonwealth versus Figura, I don't know how to say that. When multiple lesser included offences are on the table, the courts must instruct and structure accordingly so the jury isn't left wandering through options without guidance. And then Commonwealth versus Gonzalez. Yes, I did check that these are all actual cases and that the chat's not leading me up the garden path. Appellate courts frown on verdict forms that functionally steer jurors to a conviction. Sound familiar, guys? And let's not forget Sandstrom versus Montana. Even instruction that nudges towards guilt violates the presumption of innocence. So the form can be one of those types of instructions. So Kanoni knows exactly what she's doing. This isn't judicial laziness, it's active procedural steering. So there could be some appeals that could be made from this, like, even if it is an OUI. Sorry, coffee. I know you can hear me slurping here. Sorry. But it's better if you can hear me slurping so you know that I'm actually taking a swig than if you hear nothing and you're all like, are you muted? The verdict slip is the plant, Joanna. Exactly. Exactly the point that I'm making here. And exactly the point that ChatGPT sees. So, do you want to see the verdict form submitted by defense today? Yeah, you can actually send me that link in anywhere you like, Discord or Brave. Do that. Fire alarm went off. Right. Yeah, in Discord or Brave, I've got notifications turned off on Discord, but they're on in Brave. So if you send it in there, I'll hear it. Because I'm on the other screen reading. So, noting the Commonwealth does nothing. The Commonwealth does would surprise me, including a jury plant. Well, we got a little bit of information about this misnomer. Something is coming up about this, all right? I don't know. Did I actually highlight that? There we go. There is something coming up about this, so just hang in there. Shortly, Jason will join us and give us some information about this. Let me check those messages because they don't notify me either. Right, good. All right, so Kanoni knows exactly what she's doing. This isn't laziness. This is basically by refusing to revise the form and mockingly inviting Jackson to find some case law, she's daring the defence to take the appeal route, banking on delays and judicial deference if it's an OUI. So these forms undermine the presumption of innocence. They facilitate compromised verdicts, so reaching a compromise even though that's not what they would like to reach an agreement on, and virtually ensure the post-verdict appellate chaos. So, yeah. In any other high-stakes criminal trial, this form would be grounds for reversible error. In this one, it's business as usual in Norfolk County. And as we already saw, SJC, Habeas, and SCOTUS, they all just shot it down. They were all like, you know what? Deference applies. We just let the judge make the decision. We're not going to interfere with that. So yeah, that's that. What this signals about Kanoni. If neither the Commonwealth nor the defence requested the lesser included offences, yet Kanoni unilaterally inserted them anyway, then there is judicial overreach and structural bias. There is a case that could be made for that at the appeal level. But I don't know if that still stands in the case of an OUI. The OUI being inserted is kind of that it's kind of the catch-all that she's trying to prevent appeals on all this other stuff, basically. So, and she might even pull it off. So, so the problems are that it's the judicial neutrality is what's missing here. you know, her role is to adjudicate fairly, not to engineer fallback convictions in case the top charges don't stick. So thank you, Kev. Womp. Oh. Is this the fixed version? And I don't think that's the fixed version. I think that's just her version that you sent me. I'm not guilty of the offence. Guilty of offence as charged. Manslaughter. Oh, it's just the layout. Oh, he just tabbed them. That's what he's done. He's tabbed the lessers in. Because she had all the lessers on a different tab level. So he's just changed the layout of the form. And she still freaking denied it. Bitch. He just changed the layout. He just tabbed the lesser included in a little further. Let me, I share this one. Let me see. Share this one. Screen capture. Share. That screen. There you go. So he's just tabbed the lessers in. Because I think they were all just sitting like out here on this tab level, like somewhere here on this tab level. He just pulled them in, tabbed them in further, which makes it a little more clear as to what he was referring to with the lessers. So they added a not guilty option for each. Where? Guilty of, guilty, guilty, guilty. Where's the not guilty option? You're talking about this one at the top? That is the original instructions, yeah. Alright, hang on a second. That's what you sent me, but I thought you're saying this is what was attached in his. Oh, I see. Okay, let me share that one. Gotcha. You sent me two and I didn't scroll up, sorry. There we go. So this is not guilty for manslaughter while operating. Involuntary not guilty, and motor vehicle homicide not guilty. Check one of the following and then they're tabbed in. Gotcha. Next one. Yep. Operating under the influence, lesser included, not guilty. There you go. Now I see the difference. Can you bring Kevin up? Bring Kevin up what? Oh, on the screen. Hang on. I can do, because you're already in Brave, I can just switch to that screen. Let me just do that. Are you kidding me? Hang on. Let's put you over here. All right, give me a test. 1, 2, 3. I don't know what I'm doing. Give me a test. 1, 2, 3, Kevy, or type in the Brave chat if you've already done it and I just didn't hear it because the audio's not fucking working. I can hear you. Right. Talk to us.
One, one, two.
Good-o, we got you.
One, two, one.
Yep, we got you. It's you're on a
Can you hear
delay.
me?
Yeah, you're on a delay
Can you
because
hear me?
you're listening to me.
Is there anybody there? Is there anybody there?
You're listening to me
Right.
through the YouTube,
I
which is on
need
a
to get
delay.
sound through Brave because I can't listen to
Yes,
the stream. It's so far behind.
right. Exactly. You're with me. Let me send you my mic. Hang on. Yep. Let me send it to you. Oh, shit. Which one is it? Let me send you. So you hearing my mic in Brave? Because I am sending it. No. Okay. Sorry, Kev. We got some fucking around here. Am I on the right meeting? Nope. I'm on the wrong fucking meeting. This meeting. Alright, can you hear me? Hello, can you hear me now? Right. Where's my mic only? Can you hear me yet? Holy fucking hell. But not in Brave. You scared the crap out of me. Let's turn the pass-through on and set this mic up. Mic only. Yeah, sorry, dude. Give me 1 sec. I'm still frigging around with settings. Built-in. Mic only. Hello. Right, it's telling me I'm sending you my mic now. Can you hear me? How about now? Woohoo. Brave is saying yes. But you can't hear me still. Sorry, guys. This is a screw around because let's just go with built-in mic. Hello, testing 1, 2, 3. Audio output is to my headphones. Virtual, let's just do that. All right, you hearing me yet? Still no? Oh my god, guys. Let me just build a completely new scene for you. Scene Can you hear me, guys? Was I just gone for a while? All right. There we go. Kevy. Earth calling Kevy. Hello. Hello. I can hear you breathing, but you can't hear my voice. Interesting. I got everything set up in here, correct? Settings. I got my built-in microphone. Sending out to you. Well, let me just try the virtual one.
Yeah, I'm here.
There's my virtual one.
But my audio is very low and
Holy shit, you're loud. Yep, that's good. It's all working. See, my mic's going. All right. We can't bring Kevy up, guys. I think he's got some audio issues. Because that's all working on my end. And I can hear him now. Yeah, but he can't hear me, Joanna. So yeah, Kevin's not very loud. Yeah, I think actually Kevin's having some audio issues at his end, maybe. But we'll see. If this happens with Jason, then we're going to end the stream, go over to restream, start a new stream, and have a meeting with Jason. If that's how it happens. Just so you're all aware, that's what we're going to do when Jason jumps on. Start a completely new stream, and we'll do it through Restream because I know all the audio and shit works in Restream. But at this point, I think I can't tell you who's got the audio issues. One of us has. Too many things to work out. But anyway, do you want to do that, Kevy? Would you like to switch over just to end this stream, go to a new stream, and then just send Jason the link to Restream? Let's just do this a regular way, hey? And then we'll work this shit out off stream. Let's do that. I think we will. All right, chat. I am setting up a new stream. I'm going to call it the same, but it's going to be called Take 2. And then we'll bring Jason in that way, just so I can be sure that this is going to work, because clearly what I am fucking doing is not working in OBS. Clearly. All right, schedule a new stream. New. Jason. Oops. Not Hailey. Take 2. Right. Set it up. And turn that off, turn that on. Stick that thumbnail in there so that you can all see it's the same stream. There we go. Make it public. Set it for 10 a.m. Done. I can set the latency but to low this time because I actually remembering to do it. Ultra low latency. Error. Duplicate stream key. Select a new key below or go live here. Yes, I'm going to do that in a second. Just hang 10. got to disconnect from that stream key. All right, guys. I have set you up a new stream link. Let me get it for you. Fucking StreamYard's being a dickhead. Sorry. YouTube's being a dickhead. Alright. Copy this link address. Teleport from this stream. Teleport from this stream to the new stream. A bigger job than I thought it was going to be. Customize, redirect, teleport to here. Yes. Save that. There you go, guys. You all should get automatically teleported. And then we'll just go straight to restream and join it up that way. So it will be just a few minutes for the teleport and everything. I will end this stream now, and we shall send links out to everyone and get us all back on the restream. Okay, boys and girls, you can exit out of Brave Studio now to Kevy, and I'll give you the link to come up and talk on restream. All right, talk to you all over there. Bye.